started. Now they are taking advantage of the situation. We have noted the submissions of both the parties. The question which comes up for our consideration is whether the learned single judge exercise his discretion in such an arbitrary or preserved manner that the appellate court ought to have interfered with it. The learned single judge has passed a detailed order explaining as to why he was constrained to grant only the limited interim relief. It was in the interest of both the parties as well as the flat purchasers. The order passed by the learned single judge is also on the basis that anything beyond the limited protection given at that stage would deny the opportunity to the appellants to establish their case at the trial. When it is not in dispute that appellate number 1 contributed 90% of the purchase money to the property and he took steps all throughout to develop the property. Undoubtedly, there are many inconsistencies in the stories that are put up by both the parties, and an interlocutory stage is not the one where one can reach at a definite conclusion one way or the other, particularly where the fact situation is as above and it would result into non-suiting one party. As far as the order of learned single judge is concerned, it must be noted that it was a suit by one joint owner of an undivided family house to restrain the other joint owners, their heirs, from transferring their share of the house and from parting with possession to a third party purchaser and restraining the purchaser from entering into and or remaining into possession of the suit property. This was on the basis of the mandate of Section 44 of the Transfer of Property Act and particularly its proviso. This court went into the question as to whether interlocutory injunction of a mandatory character as against the prohibitory injunction could be granted. The counsel for the respondents pointed out that the mandatory injunctions were essential to avoid greater risk of injustice being caused. There is no difficulty in accepting that this court did accept that test. The relief of interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pending controversy until the final hearing when full relief may be granted, or to compel the undoing of those acts that have been illegally done or the restoration of that which was wrongfully taken from the party complaining. From a perusal of the inspection report dated 12 admitted the plan of the architect prepared after the sale deed and also produced her bank passbook to show that withdrawal to the extent of about rupees 4 lakhs had been made by her after the sale deed had been executed, which amount was utilized for the construction of the plot. She also filed her affidavit as well as that of the contractor in support of her case that the constructions were made after the sale deed was executed. However, the authorities below have relied on the report of the sub-registrar and held that there was deficiency in payment of stamp duty without even recording any specific finding that the constructions were made prior to the execution of the sale deed. It is not the case of the respondents that the land in question was undervalued. An inspection was got done after 10 months of the execution of the sale deed. It is also not the case of the respondents that the constructions found on the date of inspection could not have been made within the period which was after the execution of the sale deed until the date of the inspection. For imposing liability for payment of additional stamp duty, it would be the duty of the respondents to categorically show that there was some concealment made by the petitioner at the time of execution of the sale deed. On mere presumption that constructions existing after nearly a year must have been existing at the time of execution of the sale deed, stamp duty cannot be imposed after valuing the constructions without giving a categorical or specific finding that at the time of execution of the sale deed such constructions had existed. It is settled law that market value for the purpose of determining the stamp duty has to be determined with reference to the date on which the document is executed and not on the basis of any improvements made on it thereafter. ये जो कंटेंट है RHC लीगल का 3P का 2 नंबर है, 813 वर्ड है इसके अंदर. स्पीड बताता हूँ मैं एक बारी आपको इसकी. एक 116 के आसपास स्पीड है, 115 प्लस स्पीड है. अगर अच्छा लिखा तो टाइप कर लो.